The very fact that the Inspector General could even do that study and release that report was the result of a provision that was slipped into the Patriot Act reauthorization over an enormous resistance by the Justice Department. But reading that report was probably the tip of the iceberg of things that have been going on. Even Senator Specter, who's the ranking Republican on the Judiciary Committee, after reading the report, he referred to what he called the reckless indifference to the law on the part of the FBI. The Inspector General actually found serious abuse in 22 of the cases that they reviewed. By the way, this is not 22 out of 10,000 or 20,000. This is 22 out of 77 files that they reviewed. So the Inspector General suggested that the extent of the abuse was likely to be pervasive. What I take from that is that a reasonable degree of transparency and a reasonable system of independent checks is not only crucial to prevent unnecessary intrusions into privacy, but it's also necessary to prevent corruption. It's necessary to prevent political blackmail. And it's necessary just to prevent plain old incompetence in the government. But one of the problems that we face now is that even though Congress has started to push back, it's doing so very hesitantly. And the administration continues to be openly disdainful of Congress and openly disdainful of the courts on any issue that it can portray, stretch to portray as being some part of the so-called global war on terror. So as a result, what we're seeing is not just a change in the scope of specific law enforcement rules. I think we're also seeing a change that's much less tangible, but potentially much more dangerous, and that is a weakening of public understanding of what democratic government and what the rule of law really mean, and what democratic government, or I should say why the rule of law and why democratic deliberation are important for the survival of a society. So just to mention some specific examples from my chapter, and I won't go into all detail because I want to be sure we leave some time for discussion, but I'll just touch a few bases. One is secret searches. There's now a much looser standard for these so-called sneak and peek searches, which they're essentially a delayed notice. The search is done surreptitiously, and then sometime later the homeowner is notified that his home was searched. There's a much looser standard for these sneak and peeks, even in ordinary domestic investigations that have no relationship whatsoever to terrorism. And there's an entirely new power that's could be called really sneak and seize, a power that never existed before, to have surreptitious not only peeking but actually seizing items from the home without notice. For investigations that are related to international terrorism, but the point that I just referred to is investigations that have nothing to do with terrorism, but for ones that are related to international terrorism, there's also available now a broader authority, not just for delayed notification, but for searches in which there's no notice ever given to the homeowner. That's the typical rule now in foreign intelligence investigations, is that a sneak and peek search never leads to any notification being given to the homeowner, which of course means that accountability essentially goes out the window. Foreign intelligence surveillance, in terms of electronic surveillance, has always had very limited judicial oversight, and these tools is another example of tools that are now available much more broadly. They can be used even by ordinary criminal prosecutors. I want to be sure to mention the area of private records, which is several panelists have mentioned the national security letters, and this is an authority that affects records such as bank records, medical records, the famous library and bookstore records, and also what I think is even more important and seldom mentioned, because this is always considered the library provision, but what it affects, in addition to the books you borrow from the library, it affects the membership lists and the financial records of religious organizations, of charities, of any, you can imagine the scope of political activity that's covered by this power. And the government can now access all documents and all records, anything that has a physical, tangible substance to it, can access those with little or no judicial checks at all. And in addition, it comes with the gag order that Beeson described, gag order that prohibits any public disclosure or discussion of what they're doing. The last example I want to mention has been referred to already, the National Security Agency NSA wiretaps. It's striking what's happened here, because with all the brouhaha about the Patriot Act and how much it waters down legal safeguards, the administration chose to bypass those watered down safeguards and without seeking any amendment, any additional amendment, without seeking any new statutory authority, the administration simply went ahead and conducted surveillance of communications traffic into the United States or out from the United States without any warrant and without any judicial or congressional oversight whatsoever. So these are calls and messages for which FISA, Foreign Intelligence Surveillance Act, explicitly requires a warrant and explicitly imposes criminal sanctions for any surveillance that doesn't comply with the warrant system. But on this NSA system, the government has refused to disclose which kinds of calls are subject to this warrantless surveillance. It refused to disclose what type of internal approvals, if any, are required. It even refuses to disclose the legal reasoning that the program is based on. To me, this NSA story is especially alarming because in spite of the public exposure of this program and in spite of a fairly substantial outcry in Congress from leading Republicans as well as Democrats, and in spite of virtually unanimous view of lawyers outside the administration, whether they're typically cast as left-wing or right-wing, virtually unanimous view that this program is just flat out illegal. In spite of all that, the program essentially continues. David mentioned that the administration has backed down a bit, but they have issued public statements saying that they've changed the program. They've issued a public statement saying that a judge of the FISA court, just one judge, has signed an order that gives some sort of approval to the program. But the administration has not disclosed and refuses to disclose any information at all about what it was that the judge approved, how it differs from what they were doing before, if it differs at all. Again, they refuse to disclose even the legal reasoning that they're relying on. Even here, they trot out the argument that even to release a legal memo and to tell what cases they were citing would give the enemy a roadmap for attacking us in the future. So one other facet of this that I think is especially revealing because it arises with the new Democratic Congress, just 4 weeks ago, the administration submitted a new set of proposals for amending FISA. The administration did not in any way offer to curtail the warrantless surveillance under NSA that continues to go forward. But at the same time, they said we do need to amend FISA to give government more power. And the proposal they submitted would exempt entirely from any form of FISA oversight all surveillance of email traffic. All surveillance of email traffic whatsoever. Even surveillance of email message content would be completely exempt from any form of oversight. And they also propose to exempt all sweeps of communications traffic that are not targeted on a particular individual. That is, sweeps of, apart from email, any other calls or any other electronic communication would be completely free of any form of oversight whatsoever if any party to the conversation is located outside the United States or might be located outside the United States. You can imagine any kind of party call or any communication with several people participating as becomes virtually free game.